All right, welcome to ClickOrlando.com. I'm Justin Mormith alongside Jason Johnson of the Lowndes Law Firm. Good morning. Day 3 of deliberations beginning in just about 20 minutes, right at the top of the hour at 9 o'clock for the North Salmon trial. Jason, I'd like to first get your reaction on how long it is taking the jury in this case.
Well, jury deliberations, people always want to know, prediction of how long do you think it'll take? It's
Right.
really impossible to say. Juries don't act as single units universally throughout the judicial world. We're talking about a pool of 12 individual people with individual personalities, and you just never know until you get the jury in the deliberation room how those personalities are going to play off of each other, who will be selected as the foreperson, and the foreperson oftentimes will kind of control the process. Hopefully, with all the evidence and with the significance of the case, they're being very deliberative, and it's pretty clear, as long as it's taking, that they're being very deliberative in this process. The first day, I think they had asked for an index of the evidence. I think that was an indication that there's a voluminous amount of evidence.
There's a lot, right?
And they weren't sure how to kind of attack it. The court declined to give them that, and I think there's a very good reason for that. There are items on an exhibit list that aren't actually admitted into evidence. The exhibit list is prepared in advance of trial for efficiency purposes for the court, so you're not kind of doing everything one by one throughout the trial. And each side, for whatever reason, will decide that, hey, we don't need to admit this piece of evidence. So by giving them the entire exhibit list, it may have indicated to the jury, why wasn't this piece of evidence admitted, may have raised questions that weren't appropriate, things they shouldn't have considered because they're only supposed to consider the evidence that's actually admitted to court.
The jury has had quite a few questions. They seem to all center around the aiding and abetting charge that Salmon is facing. Does that tell you, A, that they are working on that charge right now and they've maybe already decided on the obstruction of justice, or B, they are still working on that one and haven't gotten to the obstruction of justice charge?
Again, there's no way to know, but if they're acting the way I think they may be, that the entire thing sort of hinges on the veracity, the believability of that written statement, then they may have already moved off the obstruction of justice charge, because if they're believing that statement, then she writes in there that I'm sorry I lied to the FBI, and I think at that point that count is pretty much done. The fact that yesterday they asked the judge a question about kind of the willfulness of her actions and how that tied into the aiding and abetting charge, and asked the court for examples of what would constitute that, may indicate, and my gut reaction is it tends to indicate that there may be a juror or at least one juror who believes, hey, she was just there kind of going along, didn't know what he was doing. How much does she have to actually know about what the purpose of these purchases? And that could be a good sign for the defense if that's in fact what's going on.
And it's important to note that there are 12 jurors. It has to be unanimous.
Correct.
And we don't know if maybe it's split down the middle, 6 and 6. 6 believe that she's guilty, 6 believe she's not guilty, or it's just one person who could be holding this thing up. When we think about a hung jury, because of how long this could take, and they say simply that they can't come to this, is that something that you could see happening in this case?
It's certainly a possibility, and it happens a lot that the jury will come back to the judge and say, we're unable to make a decision. And especially in a case that took this long to try and with this much publicity, it is, I think, almost a certainty that Judge Byron will say, I'm sorry, that's not good enough, try again, go back, and that may happen multiple times if in fact we have the situation where one juror or more than one juror is questioning this. They may simply still be going through the evidence and trying to decide. I tend to think, though, that going this long, we're now, we've had a day and a half of deliberations. We're into the third day, but we're really only now completing the second full day of deliberations. They may just kind of be wrapping their head around all the evidence that was admitted.
Obviously, we have a holiday weekend here. In your experience, and what do you think they could, if they don't reach a verdict by the end of today, and they say, hey, we need more time, would they come back because this is a holiday weekend on Saturday, or would they come back Monday, 2 days off?
No, they won't come back over the weekend.
Okay.
The judge will give them the weekend off, and I think Monday is technically a federal holiday, but I think the judge would probably allow them to come back in Monday and deliberate. But this is kind of where the individual, the fact that we're dealing with 12 individuals comes back into play.
Right.
I mean, they've been sitting through 3 weeks of trial now. They know there's a holiday weekend coming up. This shouldn't come into play, but these are people.
Right.
And they may be thinking, I want to get this over with before the holiday weekend so I can enjoy Easter with my family or whatever they're celebrating this weekend, if anything,
Right.
and move on with my life. And so, if I had to put money on it, I think we're going to have a verdict today.
Okay. Because yesterday around 5 o'clock, right, they asked, the jury asked for an extra hour, possibly. But then they come back about 20 minutes later and say, you know what, we'd rather just go home. What does that tell you?
Well, Judge Byron told them initially that he was going to let them go every day at 5 o'clock. The situation is at the end of each day, he goes in and asks them, do you want more time? And typically, if they say yes, that means they're pretty close, I think, to reaching a verdict. They wouldn't want to stay and go late into the night if they didn't think they were close to the finish line.
Right.
And yesterday afternoon, and I was there, we received an indication that the jury wants to stay a little bit late, and the judges told them they can stay until 6 o'clock. Now, I don't know if the jury just said we only need an hour, or if
so
Judge
he just
Byron
granted
said,
them till 6.
you can stay till 6, and then shortly after that, we heard, well, they want to go home. So, reading those tea leaves again, they could be pretty close to a verdict, but decided they may need more than an hour to get it done, and didn't want to break at that point after an hour so close, just to have to go home and come back the next morning.
And in that jury room, they are being fed.
Sure.
This is like, they're not taking breaks, they're not taking lunch breaks, they might be working through lunch, but they are, there is the point where they can kind of, okay, let's just take a quick break, let's mind our own business, because this is a very tough process for the jury, especially, if you are that one outlier who believes something that maybe the group doesn't believe.
Right.
It's like they're waiting on you to essentially do what the attorneys are trying to do and persuade you on what they believe.
And imagine being stuck in a room with 11 other people, all of whom may be arguing about something.
And they're looking right at you.
For now 2 days, and you can't get out. You can't just leave and go, take a breather. You're kind of stuck there. Yes, they're fed. But, that certainly plays into the judge's mindset, too, of not wanting to let them stay too long.
Right.
You need to be able to kind of control the tenor of the room to some extent. And, but yeah, having a hung jury, it's not abnormal to have one or more jurors say, hey, I'm not sure she did it, and then to have the other jurors kind of do their best to convince them. And getting to a hung jury is difficult because it takes a certain amount of intestinal fortitude to stand against that tide of 11 people, if it's just one, to say, I'm not sure, or I'm not convinced beyond a reasonable doubt she did it, or I'm not convinced that she didn't do it, and I'm not going to just give in. And so, it'll be tough, I think, to get to a hung jury, which is why it's so difficult for criminal defenses, especially in criminal trials in federal court, to kind of get acquitted, because it takes a unanimous decision of all the jurors that she's not guilty beyond a reasonable doubt, and I think more often than not you're going to get findings of convictions rather than acquittals, and hung juries are pretty rare.
Let me ask you this. Testimony aside, how important do you think those closing arguments were in having in maybe switching someone's mind at the last minute? Do you think does that often happen, that you have that last final word and all of a sudden someone's like, they're thinking one thing, that closing argument's delivered, and they're like, wait, and then they have to go back and think about the evidence that they had seen, a week ago, maybe a week and a half ago, and then they have to be reminded once again. So I think those closing arguments are just so important, and it may have something to do with all of these questions that are being asked.
Well, closing arguments are extremely important.
Right.
I mean, the jury has sat through 2.5 weeks of actual trial here. They've got a lot of information that's been presented to them, and it's difficult to digest all of that, especially if you're a layperson who's not trained in the law. And so the closing arguments are kind of the government's and the defense's last chance to kind of, here's our story, here's why it's important, here's why the other side's wrong. And
especially in this case when the government said on record that his intended target was Disney, not Pulse, and threw that kind of a last-minute curveball, if you will. And then these guys are like, wait. So then they have to go back to what they had this notion in their heads, essentially, throughout this entire trial that Pulse was being targeted.
Yeah, and if I've said all along that I think there is sufficient evidence here for the jury to convict her of both counts if they believe the veracity of that statement, if they believe that that statement's accurate and true. But I think if there's one strategic mistake that I think the government made, it was not arguing from the beginning in opening statements that, he may have attacked Pulse, but it wasn't his original intended target.
Right.
And we know that the government believed that this wasn't something they came up with at the end to fit the evidence, as the defense suggested in their closing, because they responded to the defense's motion in limine at the beginning of the trial, where they tried to prevent the government from saying, hey, this was an attack on the gay community. The government responded and said, we never intended to argue that. It's always been our intent to argue that this, was an attack, I think, on Disney. They knew the forensic evidence showed that. It played into their strongest argument for casing, because there was forensic evidence to show that she went to Disney Springs with him. So I'm not sure why they waited until the closing to say his intended target was always Disney Springs.
Yeah.
It gave, if nothing else, it gave the defense an opportunity to pounce and say, hey, they didn't come up with this theory until just today.
And they did pounce.
I know.
Yeah.
And I think it was the only strategic mistake I can really point to for the government.
As a lawyer and as an attorney, and as this process goes, where you're waiting and minutes may seem like hours, it takes a long. Those minutes are ticking by, and that jury has the fate of your client in their hands. What's going through your mind through that process?
Well, you kind of go back through the trial and figure, was there something else I could have done differently? You don't want to really do that in a way where your client recognizes that's what you're doing. You want to, kind of give off this sense that we've done everything we can and we're confident. I mean, they've been saying, of course, to the media that we believe in the jury and we're confident. But there's, trust me, a significant amount of questioning on their side, whether they did everything they should have, whether they should have presented a different theory of the defense. It's always Monday morning quarterbacking until you get the verdict.
Obstruction of justice carries a max 20 years.
Correct.
Aiding and abetting, max life in prison. And that is the charge that we, again, have often heard the questions being raised about that specific aiding and abetting charge, because it warrants so much, I think, too. Maybe the obstruction of justice is something that, they've kind of said, yes, maybe, too. I know we're being speculative and all that, but the aiding and abetting carries so much weight. I feel like that's why they want to get this. That's why they're being so thorough with it.
Sure. I mean, it's the charge that carries the stiffer the stiffer sentence. But you have to remember, those are maximum penalties.
Right.
The judge, and it's the judge who will decide the sentence, not the jury. The jury decides guilty or not guilty. It's the judge who will determine the sentence. And in federal court, there are sentencing guidelines. There is a pre-sentencing report. You look at the criminal history of the defendant. There are all these things that come into play. And while the maximums may be pretty high, especially on the aiding and abetting charge, and the reason it carries a max penalty of life is because death occurred as a result of the attack. But with the life penalty, it's not a guarantee that she's going to get life if she's convicted of aiding and abetting.
Right.
Especially with the fact that she's never been convicted of a crime before. This is a first offense. The minimum penalties, they go down significantly. So we could see a wide range of sentencing.
How quickly would they get to that sentencing phase once a verdict is reached, if one is reached?
It'll happen fairly rapidly. Certainly won't happen today.
Right, but in the coming days.
Yeah.
Okay.
Probably in about a week.
Well, we will see what happens today.
I think we might get one today.
Mike DeForest came through. He seemed to think that today was the day, but I thought yesterday was the day. So of course we're reading tea leaves
I've
here.
been working out of one of your conference rooms every day I've done this, but today I'm going to go down to the courthouse.
You're going to go down?
Yeah.
All right. Jason Johnson with the Lowndes Law Firm, thank you for giving us that insight. All right. For the latest on this trial, we're going to have, whenever a verdict is reached, we'll break into News 6 right on WKMG, and also have the latest on clickorlando.com where you're watching this right now. We have a 30-minute window, essentially, where we get word that a verdict has been reached, and then in about 25 to 30 minutes, a judge will bring the jury in and they'll deliver their verdict. So there is some time to get ready and to make sure you're ready to watch that come down. And again, no cameras in the courtroom, so we have reporters inside that will be handing us that information to deliver to you. So thank you for joining us this morning on clickorlando.com. Have a great day.